Good morning. I'm Leila Abed, Deputy Director of the Mexico Institute at the Wilson Center, and it is my pleasure to welcome you to our event, The Inner Workings of the Mexican Supreme Court, Opening the Black Box. We want to thank our co-sponsors, Mexico Evalúa and Arizona State University, for their support in organizing this important event. Given recent events, Mexico's Supreme Court has been at the center of policy debates that will determine the future of the country's democratic system. Whether the Mexican Supreme Court maintains its independent role as one of the main branches of government will impact not only the rules for accessing and exercising political power, but also its relationship with its two North American partners, the United States and Canada. So to discuss the court's proceedings and rules, including the role of the Chief Justice, the supermajority required for certain decisions, the assignment of cases to justices, the order in which cases are discussed, and how it compares to the United States Supreme Court, we have invited three excellent expert panelists to join us this morning. I will provide a very brief bio for each of them. Julio Rios Figueroa is a fellow at the Wilson Center and an associate professor at the Department of Law at ITAM in Mexico City. He previously taught political science at CIDE and obtained a PhD in politics from New York University. Laura Spantan is Program Coordinator for Transparency and Justice and Special Projects at Mexico Evalúa. She previously worked as the head of the press service for the French Embassy in Mexico and as a reporter for various media organizations. She received a doctorate of political science from the Latin American Faculty of Social Sciences, Flasco, Mexico, and a master's in journalism from New York University. Stephanie Lindquist is a professor of law and political sciences at ASU School of Global Politics and Sandra Day O'Connor's College of Law. She previously served as dean and arch professor at UGA's School of Public and International Affairs. Lindquist is an expert in the U.S. Supreme Court, constitutional law, and administrative law. She has authored multiple books and articles. Before I turn it over to Edna Jaime, a couple of housekeeping items for our audience before we begin. We want to remind our guests that this event will be live streamed in English and our panelists will all present in English. That said, we would like to let our viewers know that the full recordings in both English and in Spanish will be available on our webpage within the next couple of days. In addition, we encourage our viewers to submit questions for our panelists through the chat box that you can find on the Zoom screen, as well as through our website, so that you can ask panelists anything you would like for our Q&A session at the end of this conversation. And with that, I turn it over to the Director of Mexico Evalúa, Edna Jaime, who will set the context for our discussion today. Edna, the floor is yours.
Thank you very much, Lila. It is always a pleasure for Mexico Evalúa to collaborate with the Wilson Center Mexico Institute on issues that are common concerns for both of our organizations. Thank you very much to Andrew, to you, Lila, Julio Rios, for inviting us to co-organize this event, and to Mexico Institutes and Mexico Evalúa teams for making it happen. Today, we will talk about one of the most important institutions for the respect of the rule of law and therefore for democracy in Mexico, the Supreme Court. As you mentioned, Lila, we will analyze the inner workings and we'll compare it with those of the US Supreme Court. And this reflection should be of interest at any time, but it is especially relevant in the current context. The Supreme Court underwent a significant change at the very beginning of the year, when a new Chief Justice, Norma Piña, the first woman ever to hold this position, was elected by her peers to preside over them. But this change was not just great news for the symbol it represents in terms of gender parity. It implied a real shift in the way the court works. How is it possible? Julio Rios and Laurence Pantan are going to explain this in detail. But the matter of the fact is that basically the previous Chief Justice, Arturo Saldívar, was perceived as submissive to President López Obrador, and some believe that he was intentionally holding back some cases linked with controversial government decisions or policies. This is partly the reason why last year Mexico Evalúa published an investigation that Laurence is going to mention, I am sure, where she and her team tried to find out how long it takes for a case to be solved at the Supreme Court. With Mrs. Piña's designation as Chief Justice, this has changed. In recent months, the Supreme Court has resolved a number of cases that question the constitutional grounds of several government decisions and reforms, such as the decision to put the National Guard under military command rather than civil command, or an ambitious political and electoral reform called by the government as Plan B after Plan A constitutional reform on those issues, failed to reach the necessary votes, or last week, an executive order that established that all federal public works should be considered relevant to national safety, which implied that access to public information on those public works could be denied, and the public contracts for these works could be awarded without tender. And the Supreme Court has overturned them, which has unleashed the president's rage. Mr. López Obrador, who holds a daily press conference, has started to systematically question the Supreme Court, its Chief Justice, the federal judiciary, and their decisions. His criticisms have reached such level that Mrs. Piña has received threats to her life. In fact, it seems President López Obrador does not consider the law or the Constitution applies to himself or his political project. And when the court reminds him that it does, he threatens to change the Constitution. After the court's decision on the National Guard, he vowed that he had wait until after next year's presidential and legislative elections, where he hopes to obtain the qualified majority he needs to pass constitutional reforms, to present a reform to make it possible to put the National Guard on the military command. And after the court's ruling on his Plan B, he promised he had proposed another constitutional reform to change the way justices are appointed so that they obtain their position by a popular vote. On the top of that, last week, a few hours after the executive order was overturned, the president issued a new one very similar to the first one as a way to make clear that he is not ready to obey the Supreme Court's resolutions. These reactions, which are a real concern for us, put the Supreme Court under a lot of stress. This is why we consider important today, more than ever, to talk about the way the Supreme Court works and the role of its Chief Justice and cooperate with the US Supreme Court so that on the both sides of the border, we have a better understanding of the importance of the Supreme Court in the system of checks and balances and how its inner working can affect how it plays its role. Thank you, Lila. I give you back the floor.
Thank you, Edna, for your wonderful explanation and insight into the main challenges that the Supreme Court faces today and the current political context in Mexico. We will now begin our discussion. We ask our excellent panelists to each present for about 10 to 12 minutes, perhaps 15 minutes, and then we will conclude with a Q&A session. Again, we encourage our viewers to submit their questions to the chat box that you can find below on your Zoom screen or through our website, which is the Mexico Institute at the Wilson Center. So Julio, why don't we kick off this wonderful conversation with you? You can talk to us about the selection and tenure of Mexican justices, the role of the president, among other issues that I'm sure you will discuss. You have the floor, Julio.
Thank you very much, Lila. Thank you very much to the Mexico Institute, to Mexico Evalúa, and to the Center for Constitutional Design at the Arizona State University for supporting this event. It is a pleasure to share the panel with esteemed colleagues Laurence Pantan and Stephanie Lindquist, as well as Edna and Lila. Thank you so much. So let me start with a reference that is looking now strikingly familiar to many observers. On August 24, 1999, then Chief Justice of the Venezuelan Supreme Court, Cecilia Sosa, by the way, the first female Chief Justice in that country, made a stunning statement. The Supreme Court, Justice Sosa said, has committed suicide in order to avoid being assassinated. The Chief Justice made that statement after the Venezuelan Supreme Court voted 8-6 to sustain a so-called judicial emergency decree that effectively nullified the role not only of the Supreme Court, but also of the entire judiciary in favor of the recently elected Constituent Assembly dominated by President Hugo Chavez and his political party. Justice Cecilia Sosa resigned after that decision. The Mexican Supreme Court has been facing a similar dilemma. The government of President López Obrador, as Edna just said, and his political party Morena have enacted some statutes with openly unconstitutional provisions, sometimes grossly violating the legislative procedure. When asked to evaluate these laws, the Supreme Court is forced to choose between, on the one hand, its self-nullification, if these laws are not declared unconstitutional, and on the other hand, the aggressions, slander, and even physical threats that President López Obrador and his political allies are issued if the statutes are rejected. The Mexican Supreme Court, to be clear, has not committed institutional suicide. On the contrary, in particular, since the election of Chief Justice Norma Piña, the first female Chief Justice in Mexico, the court has taken its role as the guardian of the Constitution seriously, drawing clearly the lines that no government may cross. I am referring, as Edna, to recent cases such as those related to the electoral reform or the transfer of the National Guard to the Secretary of Defense, that are cases simple, legally speaking, but politically supercharged. In my remaining time, I will briefly discuss three internal institutional features that are key to understand some of these recent decisions by the Supreme Court and to explore likely scenarios in an ongoing political drama with very real consequences. These features are, first, the process of selection of Mexican Supreme Court justices. Second, the office and the role of the Chief Justice of the Mexican Supreme Court. And finally, the rules of transparency and secrecy in the disposition of cases at the Mexican Supreme Court. So first, the selection of justices in the Mexican Supreme Court. The Supreme Court in Mexico has 11 justices who enjoy a 15-year tenure, non-renewable and staggered. The appointment process is very similar to that of the United States, but with a couple of very important twists. The president in Mexico proposes 3 candidates to the Senate that, in a supermajority 2/3 vote, select one of the 3. If the Senate fails to select one, the president submits another set of 3 candidates. If the Senate rejects the second set of 3 candidates, then the president freely appoints one among the second set of 3 candidates. The perverse incentives that give the president an edge in the appointment process is apparent. During his government, President López Obrador has appointed 4 out of 11 justices. It was known from the beginning of his administration that there would be 3 vacancies in the court. However, after his government forced the resignation of one justice, Eduardo Medina Mora, in 2019, President López Obrador produced an additional unexpected vacancy. Since 1995, no single president has appointed a justice unilaterally after a second rejection by a Senate. At the same time, most proposed candidates have met the minimum requirements. But the last two appointments made by President López Obrador were highly questionable. The president push for them was strongly made, and it did have an influence. These are two justices who either were active militants in Morena, the president's party, or have direct personal connections to close collaborators of the government, or both. It is not surprising that in the recent politically charged cases in which a supermajority of justices have upheld the Constitution, these two justices have consistently voted in favor of the government without regard to the seriousness of the procedural or substantive constitutional violations that they are evaluating. There is a third justice that who has regularly voted with the government in most politically relevant cases. That is former Chief Justice Arturo Saldívar, who also exerted his capacities as Chief Justice in a very controversial manner due to his open support for the political project of President López Obrador. But this brings us to the second feature, that is the office of the Chief Justice. In Mexico, the Chief Justice is elected by her peers in a majority vote for a non-renewable period of 4 years. The current Chief Justice, Norma Piña, was elected in January of this year, 2023. This was a historic election, as Edna was saying at the beginning, for at least 3 reasons. One, Norma Piña is the first female Chief Justice in Mexico. Second, the election of Norma Piña by her peers in the Supreme Court was surprising to a certain extent, given that she was not the person that the administration of President López Obrador would have preferred to hold this seat. And third, Norma Piña is an quote-unquote insider to the federal judiciary, someone whose entire professional career has progressed from the lower ranks of the district courts to the appellate courts to the Supreme Court. Remember that the appointments to the Supreme Court are made by the president with Senate approval. This means that quote-unquote outsiders can also be appointed to the Supreme Court, that is, lawyers with no previous career in the federal judiciary. For example, law professors, private litigants, or lawyers working in the executive branch. Over time, there has been a tense balance between outsiders and insiders in the Supreme Court. But recently, the balance was tilting in favor of outsiders. Let me share with you a graph that shows the percentage of insiders and outsiders in the Supreme Court since the judicial reform of 1994. Okay, it's here. Okay, so this is joint work with Mariano Sánchez Talanquer from El Colegio de México. And part of the project that I have been developing this year during my fellowship at the Mexico Institute in the Wilson Center. As you can see, the percentage of insiders in the Supreme Court was close to 80% around the year 2000. But since 2003, it has steadily declined. Currently, insider justices are only 4 out of 11 in the Supreme Court. In fact, former Chief Justice Arturo Saldívar was the first outsider Chief Justice. Chief Justice Saldívar's tenure was highly polemical. Many observers considered that he was too close to López Obrador and his political project. Let me stop sharing. The election of Chief Justice Norma Piña, an insider highly regarded by judges and officials in trial and appellate courts, brought new strength to the Supreme Court to face the quotidian verbal aggressions lashed out by President López Obrador and his political allies. The Chief Justice in Mexico not only presides the Supreme Court, but also the Judicial Council, the institution that administers the human and material resources of the federal judiciary. The Chief Justice position is mostly administrative. He or she manages the Supreme Court and the judiciary, but it is also a political position because the Chief Justice represents the judiciary vis-a-vis the other branches of the state, the executive and the legislative. The Chief Justice, finally, also has some agenda-setting powers through her role in the distribution of cases within the court and the deliberations amongst the justices, something that Laurence will talk more about in her presentation. From the very beginning of her tenure, Chief Justice Norma Piña emerged as a figure who wouldn't stand for the entire judiciary, defending the integrity of the federal judges against unsubstantiated attacks. In return, Chief Justice Piña has obtained support from federal judges and officials. The strong corporativist tradition of the Mexican federal judiciary has produced, indeed, some negative connotations and outcomes. But in this critical political context, it has come out as the backbone that is helping the Supreme Court to draw the line of the most basic constitutional limits to this and indeed to any other democratically elected and responsive government. Drawing the line is key, but it won't be enough. Civil society and citizens will have to hold that line. Will they? That is an open question. In some recent polls, however, the percentage of people that approve of the work of the Supreme Court is actually a little higher than that of President López Obrador himself. This is at least in part due to the third and last feature that I will discuss, and I will do it very briefly to not exceed my time. This is the transparency versus secrecy procedures in the Mexican Supreme Court. We can talk about this more in the Q&A part. The public attention to the Supreme Court is not only due to the daily aggressions in the morning conferences of President López Obrador that make headlines, but also to the added drama that comes out with the public broadcasting in real time of the deliberations of the Supreme Court. In Mexico, in contrast to the United States, the hearings in which the parts to a case argue before the justices are secret. This is surprising and hard to understand, but it is real. Lawyers can schedule appointments with specific justices to argue their case, sometimes even without the presence of the other lawyers of the opposite party. However, the deliberations in contrast to the US, the deliberations amongst the justices and their votes to dispose cases are not only public, but also televised in real time. The recent highly political cases have attracted the attention of many people, drawing probably increasing support to the Mexican Supreme Court in this political context. In any case, and with this I finish, if there is a single thing clear in the increasingly uncertain political context in Mexico, is that drama, unfortunately, is not lacking. Between the mañaneras of President López Obrador and the public deliberations of the Supreme Court, there is barely time to watch Succession. Thank you very much.
Thank you very much, Julio. That was extremely interesting, not only in your explanation as to how the justices are appointed in the Mexican Senate, but really the unilateral powers that the president can have under a certain circumstance, as well as, the position of the Chief Justice, even though it is very legal in a sense, it also has a deep political, position to what the Chief Justice can do and what it means for the rest of the branches of government. We are now going to have Laura Espantan talk to us about the internal organization of the Mexican Supreme Court and how cases are selected and assigned, as well as the internal procedures in the court and how those affect its decisions. So, Laurence, wonderful to have you here, and we can't wait to hear everything you have to say about this issue.
Thank you so much, Lila. Good morning to everybody who's connected with us today. And it's a pleasure for me to share this roundtable with you, Lila, with Edna, and of course with Stephanie and Julio, who are two experts whose work I really admire. To start with, I think it's important to say that the Mexican Supreme Court is a constitutional court, but it can also be the final appellate court in some cases. But unlike its US counterpart, the Mexican Supreme Court does not choose the cases it will review because it has an obligation to hear many of those it receives, actually. So this implies that it decides more than, could you please switch the slide, please? The next one? It implies that the Mexican Supreme Court decides many more cases than the US Supreme Court. For instance, last year, the Mexican Supreme Court received more than 13,800 cases, and it decided more than 2,800, in contrast with the 100 or 150 cases that are decided every year by the US Supreme Court. Now, how do cases move through the Supreme Court? When a case arrives, the Chief Justice assigns the case to a justice on the basis of a strict rotating order determined by seniority. In constitutional cases, which are decided by the court in plenary sessions, the admission is decided by the justice, whereas in review cases, which are normally decided by one of the court's two chambers, the admission is determined by the Chief Justice, him or herself. And when the case is admitted, in some cases, the justice conducts hearings, or they request a report from the executive and legislative branches, or the justice directly starts to study the case in order to write a draft decision that he submits either to the plenary or to the chamber. In the chambers, draft decisions are usually discussed and voted on a first-come, first-served basis, even though some justices can decide to put their draft on hold, in a way, for an undetermined amount of time without justification. But in the plenary, even though draft decisions should be discussed and voted in the same order they are submitted, the Chief Justice has ample leeway to alter the order in which drafts are discussed. And when they vote on the constitutionality of a law or an act, justices must reach a supermajority of 8 out of 11 justices to cancel it. But when it comes to jurisprudence, a decision by the plenary should reach the same supermajority of 8 out of 11 justices. And in the chambers, it must meet a majority of 4 out of 5 justices. If a simple majority is reached, but not the supermajority, the decision applies to the specific case being discussed, but not to future similar cases. We found out about the discretional leeway that I was telling you about a moment ago during an investigation that we published last year under the title Observatory of the Supreme Court Diagnosis on Procedural Transparency. And in this investigation, what we were trying to confirm was the perception that had been historically widespread, that is, that some cases lasted much longer to be decided by the courts than the average, especially when they involved government, political, or economic interests. To do so, we tried to calculate the average time it takes the court to decide a case. When I say we tried, I say that because to do so, we needed to have access to some information, especially dates related to the different stages cases go through when they are in the court. And now, actually, what we find is that actually the path to get this information was not that easy. And to complement what Julio said about transparency, it's interesting because the Mexican Supreme Court has been recognized internationally for its transparency because its deliberations are public and broadcasted, which can be good or not so good, and maybe we can talk about that in the discussion. But what we discovered is that it is not at all transparent when it comes to the different procedural steps or stages a case go through once it enters the court. And indeed, if someone wants to know, at what stage an ongoing case is, they will have a hard time finding the information on the court's webpage or when they ask the information through formal access to information requests to the court. As for us, when we requested the dates of the different stages of the 4 main types of case reviewed by the Supreme Court between 1995 and 2021, the court replied that with databases from 2 different sources within the court. And our first problem is that we found contradictions between those databases. We also found that some, dates were obviously mistakes. For instance, when the date of a notification of a decision was prior to the date of the decision. That's impossible. So we found many mistakes like that in the database we were given by the court. We also encountered many missing data, as well as information the court argued that it did not register. For instance, it said it does not register the date when a justice submits a draft decision, which is a very important data if one wants to know whether the delay to decide a case is due to a justice that took very long to submit his or her draft decision, or to the Chief Justice decision, to postpone the discussion of the case in the plenary. And despite the lack of information, we confirmed that a significant number of cases took much longer than the average to be decided by the court. In fact, as you can see on the slide, 6.8% of constitutional controversies and 6.7% of constitutional actions, as well as 5.5% of amparos and revision, I'm sorry, I couldn't find a translation for this kind of case, took longer than average to be decided by the court. We also find some cases that were not yet decided, but when we conducted the study, and that had already exceeded by a significant amount of time the average time resolution time. For instance, up until September of 2021, 1 constitutional controversy and 2 amparos directos en revisión had not yet been decided in 8 years. We also find 6 constitutional actions and 1 amparo en revisión that were waiting for a decision for more than 5 years. But as I mentioned, because we couldn't obtain the dates of all the different stages of the case's process, it was difficult to know the reason for these delays. In order to have a better understanding of this issue, we've also analyzed a few specific cases in more depth in order to understand what caused the delays. For instance, we look at this case, the constitutional controversy 96, /2007 that was linked to the regulation of the public notary profession, to which, by the way, several justices belonged before joining the court. So it was a very sensitive case, and it took more than 2 years and 9 months to be decided, when the average resolution time for a case of this type is a bit less than 1 year and 3 months. But the interesting thing we discovered is that it was on the list of cases to be discussed by the plenary for 8 months, which means, and that before it was decided, actually, for 66 sessions, it appeared at the bottom, very bottom of the list, which means that any other case that was put on the list after was given priority over this case without any justification. Now, as for the constitutional action 46/2016, linked to the role of the military and the public safety task, an important actually case for the government, it took 6 years and 11 months to be decided. But in that case, the main reason for the delay is that it took more than 5 years for the justice in charge of writing the draft decision to actually submit it. And when it was submitted and put on the list, twice it was downgraded 60 positions with no explanation. It's important to stress that we don't mean to say that cases should be decided fast-tracked no matter how. On the contrary, we believe they must be decided based on the necessary study and in the shortest possible amount of time without arbitrary delays. Now, we also analyze the case of each justice. And first of all, we found that even though the distribution of cases among justices is supposed to be balanced, there is actually, it's not the case, or it has not always been the case. For instance, in 2014 and 2015, while some justices received less than 200 cases, others had to review more than 300. It's a huge difference, and it means a very different workload. And we also found another interesting thing is that the average resolution time is not directly related to workload. Now, when we compare justices' average resolution time between 1995 and 2021, we encountered very different results. Some of the first justices of the period needed as low as 110 or 152 days to decide their cases, whereas another one, who is still in office, needs an average of more than 356 days to do so, a difference of more than 60 days than the next justice that is listed here. The numbers are to be considered with care. It's important to say that we only could calculate the average time between the moment a case enters the court and the moment it is decided, and not the exact time between the moment the case is actually assigned to a justice and the moment the justice submits his or her draft. But the reason for this is, as I said, a problem of the data that we could have access to. And on top of this, in some cases, it is true that parties involved in a case may present motions that imply a delay. And on other cases, it's also true that some cases are more complex than others, and they need more time to be reviewed. But in any case, these considerations apply to all justices alike. In the end, these numbers suggest that some justices are more efficient than others. And it is interesting because actually each justice can organize the work of his or her team the way he or she wants. 15 years ago, all justices could hire the same amount of positions in their team, but this changed, and now each justice is awarded the same budget to hire their team, but they can choose whether they want to have more or less clerks. For instance, when we reviewed this issue in January of 2022, one justice had 9 clerks, whereas another had 15. This is a huge difference. And in fact, inside each team, some justices distribute their cases between clerks according to the matter of the case, others according to the types of cases, and others according to a strict rotating order, which means their clerks are not actually specialized. These different kinds of organization inside the justice system seem to have an impact on their efficiency. Let me now conclude with a positive note. The good news is that Chief Justice Norma Pina read our investigation and was interested in some of its findings. And since she was appointed Chief Justice last January, she already has put into practice 2 recommendations that stem from the study. First of all, she created a commission of 3 justices to review the list of cases that are to be discussed by the plenary, which means that she actually was ready to reduce or to actually control the discretionary leeway she, as a Chief Justice, could have in that field. And on top of it, she gave instructions to develop a website to publish the dates and details of all the stages, constitutional actions and controversies related to the electoral reform that both Edna and Julio mentioned, that was promoted by the government, go through. So we were told that this is a pilot program that eventually seeks to publish the whole information for all cases. So those are good news, and I think it's important to stress those good news and not to stay just on the, pessimistic note. Thank you very much for your attention.
Thank you very much, Laurence. That was extremely interesting, especially how long it takes for a case to be decided. I mean, I think that that's something that I would love to hear from Stephanie as well, who is up next, and how that compares to the Supreme Court in the United States. So we will continue the conversation with Stephanie Lindquist, who's going to not only discuss current debates around SCOTUS, but also relevant issues in the Supreme Court in the United States that compare to the Mexican Supreme Court. So we're eager to hear you, Stephanie. Welcome.
Thank you so much, Leland. Thank you, Edna and Julio, for inviting me. Thank you, Laurence, for that, what is obviously a yeoman's effort to gather data and analyze it in Mexico. That's very impressive, and thanks for that presentation. I thought I'd begin just by noting that the current situation in Mexico with respect to conflict between the executive branch and the judiciary is something that's commonplace and has been commonplace across democracies, whether they're established or developing. In the United States, of course, this came to an early head in 1803, when the Chief Justice Marshall, who's widely perceived to be the most influential Chief Justice in the court's history, came into conflict with the Jefferson administration over an appointment to a justice of the peace position, actually a fairly minor judicial position. And what Marshall had to do in that case was avoid conflict with the Jefferson administration. He did so by essentially avoiding the issue of whether he could mandate that the Secretary of State issue the particular judicial commission to the individuals who had brought the suit. And in so doing, he struck down a federal law and thus confirmed and affirmed the Supreme Court's right and power to exercise judicial review and invalidate legislation. So he had to be, in a very important sense, strategic, because he understood that if he ordered the Jefferson administration to do something and they chose not to do it, it would threaten the legitimacy of the very fledgling institution that was the Supreme Court at that time. And so we've seen that throughout the Supreme Court's history as well. What came to mind most recently in terms of cases in the history of the US Supreme Court was a conflict between the Truman administration and the US Supreme Court, having to do with a kind of seizures that we've seen in Mexico by the president there in the name of national security. So in a case in the 1950s during the Korean War, Truman issued an executive order, very much like AMLO is doing now with respect to railroads, et cetera. And he issued an executive order to seize the steel mills, the privately owned steel mills in the United States, on grounds that he needed to do so because of labor conflicts within those steel mills was stalling the production of steel. And this was taking place during the Korean War. And so he claimed, for the sake of national security and the nation's efforts to conduct the war in Korea, that the executive order was necessary and was authorized by the Constitution. The Supreme Court stepped in, concluded that the president had acted outside his authority. He was doing so without the acquiescence of Congress or the support of Congress, and therefore the Supreme Court struck down the executive order as unconstitutional. Now, in that case, by the time we got to the 1950s in the United States Supreme Court, the court had sufficient institutional power and independence that it had developed over the course of its history that the president acquiesced to the Supreme Court's decision. In Mexico, we have a slightly different situation, of course, in that we have a fairly new court, if you think about its development since 1994. And so it really only has 30 years of developing under its current constitutional design, as opposed to the Supreme Court. But that doesn't mean that in the US, these issues do not, occasionally arise. And the issue of compliance, which is what's being seen in Mexico, is critically important for the legitimacy of the institution. So we are right to be very carefully focused on the current Chief Justice and how she is managing these conflicts. Now, one thing that I think about, I meant to start my timer. So Leila, if you just wave at me if I've gone over time. One thing I think is worth thinking about in the context of the Mexican Supreme Court, as well as the Federal Electoral Tribunal. Now, the Federal Electoral Tribunal is the institution I've spent most of my time helping analyze and more or less consulting to on their institutional designs and decision-making procedures. And the way I see Mexico is sort of in a position or a point between civil law system and a common law system. So the Mexican Supreme Court, as well as the Mexican Electoral Tribunal, have instituted a system of precedent. It is an unusual system in that it requires a sequence of decisions that are consistent with each other before precedent can be established. But that is certainly more of a common law system than a civil law system. And as that transition takes place, I think these institutions are sort of evolving to accommodate that different kind, or at least a hybrid system of civil and common law approaches to judicial decision-making. And in the context of the Federal Electoral Tribunal, I evaluated some of the things that both Julio and Laurence have mentioned. For example, in the common law system, what we call ex parte communications with individual lawyers without the opposing counsel present is strictly prohibited. And the reason for that, of course, is that it encourages transparency if both parties are there. In addition to that, it reduces the appearance of bias that can arise from ex parte communications. And I had strongly recommended to the Electoral Tribunal and the justices there that they eliminate ex parte communications. The other point that Julio has made about the deliberative process in terms of the transparency or in terms of the secrecy is that, to me, it's absolutely flipped. The deliberations of the justices that take place in real time, I guess on Zoom, that's the way the Federal Electoral Tribunal works, seems to me to be exactly the opposite way to do it, where the oral arguments, to the extent they exist, should be public for sure, because that reflects and I think bolsters public confidence in the courts that they are actually hearing both sides of an argument and hearing the justices ask questions to the extent that happens. Whereas when the deliberations are public, what that means is that we have the individual justices, at least in the electoral tribunals I've seen, simply stating their positions and not actually engaging in any, substantial deliberation at all. So it undermines the whole notion that we're operating as a collegial court where the justices are making decisions through the deliberative process and through the conversations and discussions with each other. And that is most likely to happen effectively in the privacy of the justices, of the courthouse and of the justices' chambers. So I also thought that could be a change that would be very beneficial as the courts make this transition again from a civil law to more of a common law hybrid system. Also on the discretionary docket, the real point that Laurence has raised is this issue of law as sort of justice delayed is justice denied. I agree with that 100%. At the Supreme Court, of course, they resolve all the cases that they have on their docket within a year, from October to June, actually. The reason they're able to do so is because they have a discretionary docket. And that has been an enormously important change in the court's institutional kind of processes, procedures since 1925, when Congress essentially authorized the court to exercise its discretion over what cases would arise on its agenda. And that has not only given the court a lot of power because they can choose both what cases to decide, politically speaking, that are important to them, but also what cases not to decide. And there is a value on both sides of that in terms of ensuring that the court can avoid political confrontations from time to time, right? Exercise their agenda setting process in a strategic way, and thus maintain the court's institutional legitimacy. And this has happened many times. The one example I can think of is we have a Pledge of Allegiance. Every high school and elementary school student has to pledge allegiance to the flag before school every day. And in that pledge, it says under God. And so there was a challenge on separation of church and state grounds to the pledge, which is widely, used across the United States and is sort of loved by all Americans in many ways. And the court was able to avoid evaluating the constitutionality of the Pledge of Allegiance by ensuring that the case stayed off its docket for reasons associated with standing doctrine in the U.S. So very interesting ways that the court can avoid confrontations or reduce its popularity. Now, one other thing about Laurence's presentation, and this is very critical. One thing we have in the U.S. that apparently is not available in Mexico are two sources of data that are incredibly important. One is the Federal Judicial Center, which operates under the Administrative Office of the Courts of the U.S. courts, which is under the jurisdiction of the Judicial Conference. The Federal Judicial Conference is like the Judicial Council that you have in Mexico. And this is an organization that gathers data on every single case, including all the relevant dates that you mentioned, Laurence, from the trial court all the way to the U.S. Supreme Court, identifies the outcome of the case among many, many other variables. These data, which I actually worked at the Federal Judicial Center for a year, I analyzed these data. They're incredibly comprehensive and publicly available. So that's important, that database. And in addition, on the U.S. Supreme Court, a series of scholars have gathered data. It's archived at Washington University in St. Louis, and it also records a number of variables, many variables actually, associated with each case that the U.S. Supreme Court has decided since the inception of its history. So data is so important to enable not only scholarly review, but also journalists' ability to critique the decision-making processes and outcomes of the courts themselves. And so I really commend your effort to develop those data. Now, I just want to say in the time that I have left, which I think is about 3 minutes. Do I have that right, Leila?
You're good. You have about 5, so you're okay.
Okay, great.
Yeah.
I just want to say a word about the importance of public support for the courts. Now, as Julio mentioned, and I'm very encouraged to hear that the Mexican Supreme Court is actually enjoying greater popularity among the citizenry, even than the president. That's actually very, very good news, because that suggests that the president will pay a price for failing to comply with the court. That, of course, is the objective, right? You want to be sure that your executive officials, and especially the president, are actually held accountable for non-compliance with judicial orders. And that will only happen if the judiciary actually has the support of the electorate. So that's very, very good news, I think. In the U.S. Supreme Court, we have exactly the opposite problem at the moment. I just want to say a few words about this. We have a perception among the electorate in large part that the Supreme Court has become too powerful. And as we know, independence really follows a bell curve. And there can be too little independence and too much independence, but there's a sweet spot in the middle somewhere. And the issue at the U.S. Supreme Court is that some members of the public and of the elites as well consider the Supreme Court to have become too powerful. And one of the key reasons for that is that the only way to counter, especially constitutional decisions by the U.S. Supreme Court in the U.S. is by way of constitutional amendment. So when the U.S. Supreme Court interprets the Constitution, then the reversal of that decision may only happen by constitutional amendment. And for those on this call who have been following what happens to the U.S. Constitution, we've only had 27 amendments in the history of the U.S. Constitution, and 10 of them were initiated in 1790. So very few constitutional amendments, and we haven't had one since 1992. That suggests that the U.S. system of constitutional change has stalled and relative to amendments, and has transferred that power to amend the Constitution has been transferred wholly to the U.S. Supreme Court. And recent decisions by the court that some perceive as activist, although that's been a charge leveled against the Supreme Court throughout its history. But those recent decisions, especially the decision overturning the right to federal protected right to abortion in the U.S., as well as some major ethics concerns that have been elevated to the public forum involving particularly Clarence Thomas accepting hundreds of thousands of dollars of gifts from a donor, or not a donor, although it looks like donations, no, from a friend, has drawn into question the unbiased or the integrity of the court. And because of separation of powers concerns, the U.S. Supreme Court is not answerable to Congress, and its procedures cannot be changed for the most part. There's some major exceptions to this, but when it comes to the internal deliberative processes and the ethics rules that govern the court, cannot be changed by Congress. And so we really are at an impasse in the U.S. Supreme Court and in terms of its legitimacy in the U.S. And we've seen, unlike in Mexico, a diminution in public support for the court. At a high point, I had a slide and I'm happy to share it during Q&A, at a high point of 80% favorable rating to the court in the mid-1990s, now down to 48% favorable rating. Now, that's still higher than Congress and the president, but it really does show a significant decline over time, and something that the U.S. Needs to pay very careful attention to in the interest of preserving the rule of law. So I'll stop there. Thank you so much again for the opportunity for me to share these thoughts about the U.S. Supreme Court.
Thank you so much, Stephanie. And I think that was a perfect way to end your conversation and to end all the insights that you provided, because I think, the credibility of the Supreme Court, of the judiciary branch is so important in all democracies. As you mentioned at the beginning of your presentation, it's the tension not only between the Supreme Court and the president is something that occurs in advanced democracies, but also in developing ones. So I think that's something to think about as we jump into this Q&A session. And so with that, I will encourage our viewers once again to submit their questions through our website or here on the chat box. But we have received several questions. So we will start with the first one, which is directed to Laurence and to Stephanie. What are the advantages and disadvantages of a supermajority vote in the court to declare unconstitutionality? There we go. Third time. There you go. It's a little bit of jet lag on my end. I apologize. So I don't know who wants to start, Stephanie or Laurence? Why don't we start with you, Laurence, and then we'll move to Stephanie.
Yeah, sorry, because I couldn't get my, go ahead, Laurence.
It's okay.
No, go ahead, Stephanie, please.
Well, so thank you so much for this question. This is a proposal that has been advanced in the United States to rein in the power of the U.S. Supreme Court. There are 3 states in our republic that do require supermajority vote before a piece of state legislation can be invalidated. So this has been advanced as a proposal for the U.S. Supreme Court. And the criticisms of it, and I'd be curious to see what Laurence says about how it works in Mexico, but the criticisms of it is that it creates some confusion. So in the U.S., we have 9 justices. And if we had a supermajority, for example, it might require 6 justices or 7 to invalidate. And it's been proposed, by the way, in the history of the U.S. Supreme Court. These have been proposed, never adopted. It would require the U.S. Supreme Court to have a 6 or 7 vote majority to invalidate legislation. And as Laurence pointed out in her presentation, if that is not reached, it can create confusion, right? In her case, and what she mentioned was that in that particular case, the legislation cannot be applied because it's unconstitutional in that unique case, but that in general, it's not been invalidated, as we say in the U.S., on its face in all particular applications that might be subject to that statute. There's a lot of confusion there. And so the proposals for a 2/3 majority have never been adopted in the U.S., probably would require a constitutional amendment for the reasons I described earlier. But it is definitely something that we've been discussing here. Go ahead, Laurence.
No, and maybe also Julio has an opinion on that I'm sure will be really interesting. For me, I agree on what you said, Stephanie, because that's the case in Mexico. It's very confusing. Many people don't understand, and even sometimes justices, get stuck. I will take an example. There was a discussion about the law on electricity, the way to produce electricity in Mexico. There was a case about that, and when the debates were going on, at that moment it was a few years ago, if I'm correct. The Chief Justice was Arturo Saldívar, and the way he was bringing the debate. He did it in a way so that it was not invalidated, even though the supermajority was reached, but on different grounds, for different reasons. And that was so confusing that even justices were like, but we just invalidated it. And Chief Justice Saldivar said, no, you didn't reach the supermajority. So this is confusing even for justices. That's what I mean. And the other reason also I think it's problematic is that, sometimes actually even we've seen that when there's just one vote short, if sometimes justice decide to change his vote to reach the supermajority because he knows, there's a majority already. Why, it's not fair that because you're short of one vote, the decision shouldn't be, reached. So I think it's a problematic situation. I'm not in favor of supermajority for this reason, but maybe Julio has a different point of view. I don't know. So.
Thank you, Lorenz. No, I agree that it introduces a lot of unclarity, as Stephanie, as Laurent were saying. It also invites a lot of litigation. We have seen in Mexico that this particular case that was short one vote, the law is still valid, but lawyers on behalf of their parties are making the argument against in trial courts that, like a majority of justices declared that this wasn't constitutional. So they are fighting. So it creates a lot of trouble. I will only add that it is, as Stephanie said, well, in the US, it has been proposed several times, but not adopted. In Mexico, this was adopted in a very peculiar circumstance in the reform of 1994. This is new, and it's only for two types of cases, the constitutional controversies and unconstitutional actions. And in a very nice work by Beatriz Magaloni, Eric Magar, and I am forgetting her name, like a co-author of theirs, they found out that in the reform of 1994, that introduced 11 justices, and all 11 were appointed new. It was a packing of the court in 1994. Only 7 of those 11 justices were approved by all parties in Congress, essentially the PRI and the PAN and also the small PRD party. 4 of them were appointed strictly along partisan lines by the PRI, who was in power at that time. So the argument is why this supermajority rule that requires at least 8 of 11 votes. They say, well, probably it has to do with a kind of insurance on behalf of the governing party, saying, well, so we appoint 4 judges that we believe will be more sympathetic or more careful in future cases. And I don't know. I mean, it's interesting to look at the adoption of these reforms because it involves these political calculations. Of course, then things change, and now and calculations are different. But I will stop there.
Thank you all. Julio, since you are already on the microphone, there is a question for you. But again, if any of you, Laurent, Stephanie, want to chime in, please feel free to do so. In terms of Plan B and the Supreme Court's decision, what else can President López Obrador do to undermine the judiciary branch in terms of electoral law?
Okay, thank you. So the first part of Plan B has been rejected by the Supreme Court. The second part of the Plan B, the part that actually weakens the electoral institution, is still to be decided by the Supreme Court. So that has to happen. I want to mention briefly here something regarding Stephanie's comment that because I agree that, yes, in a democracy, it is like clashes between branches are kind of regular, are to be expected. The question in Mexico is if we are in a regular political context or in a democratic erosion context, because people who are alarmed are in part saying that, well, this is not normal. Of course, in a democracy, these things happen. But what we are saying, in particular regarding the reform to electoral institutions, not only the INE, but also the Electoral Tribunal, might be stepping a little bit out of the bounds. So that's that. It's, I don't know. I mean, I won't say where we are. It's interesting to see, as Stephanie mentioned, Mexico's democracy is like 30 years old. So it may be the first real stress test to Mexican democracy. And if we go through it, then institutions learn and adapt. So part B is still to be decided. President López Obrador has already said that if Plan B is rejected, then he will propose a constitutional amendment, which is okay, before he leaves office, once the new Congress is elected next year. So in effect, what he's saying is elect people, representatives from my party, to have a supermajority in the legislative branch so that we can change the Constitution and get rid of the Supreme Court in the way we know it, and instead elect judges via a vote, like a popular vote, as Edna was saying at the beginning. So this is what, like, plan, I don't know, like C of President López Obrador. I don't know if he will carry out with it or not. He said the same thing regarding the military, the reform to the military. So that is to be, I think it's fair in the sense that, like, the people will vote. If people will vote for it, it's okay, assuming that the electoral institution is able to organize elections and count the votes as it has done in the last 30 years.
You know, I just want to add one point to that too. First, there's nothing stopping a democratic electorate from electing an authoritarian. We're facing that. We're going to be facing that problem in 2024 in the U.S. without a doubt. I mean, I just feel it's fairly. I'm confident that Trump is going to be the Republican nominee, so we're going to be facing that challenge. And obviously, Turkey's facing that right now. Various and Mexico as well. The one other proposal, as I understand it, and Julio mentioned, is to change the institutional design of both the Electoral Tribunal and the Supreme Court to have them be elected bodies. And that, of course, is the case in more than a majority of cases in the U.S. In terms of state Supreme Court justices and also lower court state court judges. And so it's worthwhile looking at the consequences. I mentioned this. I testified at one of the sort of pop-up hearings that Morena held last fall about Plan B and Plan A. And I mentioned there that there are significant consequences for having judges be elected. Not all bad, some very interesting and potentially good. But the fact is that has to be carefully evaluated, and especially at the national level, to have the national Supreme Court elected will simply politicize that body even more. So I just want to mention that.
Very interesting.
If you let me, Lila, just to make a quick, point, just to say, because Stephanie mentioned something really interesting, the difficulty to amend the Constitution in the US, which is quite different to the situation in Mexico. In Mexico, you need a supermajority, but it's very easy to reach. So easy that every now and then you have constitutional amendments. That's a big difference. The Constitution in Mexico has been modified. I don't have the data. I'm sorry, maybe Julio has it, but so many times. So this, the scenario Julio mentioned, the fact that the president asked people to vote for his party in order to make this constitutional amendment possible it's realistic. It's not, an imaginary scenario. It can happen. Just to make this, point. Thank you.
Great point, Laurence. Thank you so much for that. All right. The next question that we received from our audience is, how important is the discussion on reducing life tenure of justices, both in the United States and Mexico, and how could it impact the inner proceedings of each of the Supreme Courts? Anybody want to kick that off?
Actually, just to make that point, because Julio said it, in Mexico, justices don't have life tenure. They have a 15-year tenure. So in Mexico, that's not being questioned so much, the length of their tenure. I don't think so. That's not the big issue. The big issue is how they are going to be appointed. But maybe Stephanie can say something about life tenure in the US.
One of the most prominent proposals, in fact, to reform the US Supreme Court is to eliminate life tenure. That is written into the Constitution in stone for both US Supreme Court justices and all lower federal courts judges as well. And the concern, of course, is that justices are being actually appointed at slightly younger ages, especially by the Republican Party. And given the state of healthcare, they're living slightly longer. Now, this is not dramatic data. There were some, early judges and justices on the U.S. Supreme Court in the early part of our history that served 33, 35, 36 years on the court. But that is a current complaint about the court, that they are appointed so long ago, they've lost touch in some ways with the political pulse of the nation. And so the problem is, in the US, is instituting such a reform. It has to be constitutionally mandated without a doubt. And then how do you actually there's one statutory proposal I can talk about, but generally speaking, it would require some kind of constitutional amendment, which we know is not very likely in the US, as I mentioned. And the issue is transition, because each Supreme Court seat is very valuable to the president sitting in power. And sometimes the Senate has actually refused to hold hearings and confirm a nominee from a president, as we saw under Barack Obama. And so getting the chance for that nomination is incredibly important. And so how do you transition from a life tenure where judges are seated on there for life tenure and can't be removed to a system of, say, 18-year terms? And that's where the rubber meets the road. That's the devil there is in the details on that. And so, but I think term limits, we are the only major democracy in the world that has life tenure for its national constitutional judges. So we are way out of pace with what the rest of the world does. And let's face it, there's no complaining about judicial independence in many advanced democracies simply because they only have 15 or 18-year terms. So it's a good question.
Wonderful. Thank you, Stephanie. Nobody else wants to? I can move on to the next question. Okay. The government of President López Obrador consistently says that the decisions of the Supreme Court violate democracy because the Supreme Court justices were not elected by popular vote like the majority of the representatives in the legislative branch. Would the popular election of judges solve this problem, or justices? Julio, you want to start? Or Laurence?
Yes, thanks. There is a real concern, let's say, like legitimate concern of behalf of many people in the in Mexico, that when the Supreme Court, whose members are not popularly elected, overturn decisions by the elected representatives, they are actually undermining the majority will, and therefore the basis of democracy, majority rule. So we have to be careful. I mean, there are of course some questions that are very complex in legal terms, in which 9 or 11 justices can side with one of the parts in the discussion and therefore create problems. And then I think it does create these legitimate concerns. So I won't enter into those difficult cases that still can be reverted through elections, as Stephanie was saying. I mean, people still will elect new representatives in the next election, and then things can change. Precisely life tenure, or a tenure that is longer in justices than that of representatives, allows that judges have a certain removal from current debates, day-to-day debates, but at the same time, they are not very out of touch with what the people wants, what the people thinks as expressed in general elections. But in Mexico, in these cases that we are talking about in Mexico, that we are talking about very, as I said, simple, very simple cases, legally speaking. These are cases about procedural rules. These are cases about open unconstitutional provisions in statutes. So in those cases, I think it is very important for the sake of the majority, that the Supreme Court overturns it. Because, for instance, when the legislative majority violates procedure to approve laws, what is violating is its rules for debate in the Chamber of Deputies, rules that allow the minorities in the chamber to express their opinions, to negotiate, to bargain. I mean, procedures that actually strengthen democracy and the representative process, the representative government. It is actually, like, surprising that Mexico's government, who has a majority in the legislative branch in both chambers, have actually violated the legislative procedures to approve laws. I mean, they actually have the majorities to approve laws in a procedurally correct manner. So all this to say that when we are talking about these very basic rules of procedure, very basic rules of consistency between what the Constitution expressly mentions and what the legislator is doing, then it is correct for the Supreme Court to overturn those laws, and that only defends the principle of democracy, like a representative democracy. I don't think there is a challenge for democracy in those kinds of decisions. I don't know what Laurence and Stephanie say.
I just want to say something real quick and direct. Thank you. That's very helpful, Leo. But directly in response to that question, do elected courts solve the anti-democratic nature? Yes. I mean, clearly, right? If you're electing courts, they're elected. They have a direct electoral connection to the electorate, and therefore one might consider them to be more democratic if you think about the electoral accountability as the measure of democratic institutions. However, what I would say to Lopez Obrador is be careful what you wish for, because in the United States, elected judges tend to be more independent in many respects than unelected judges if you make comparison across the states. Why, you ask? They're more independent because they have their own electoral base of support. They can thumb their nose at the legislative branch or the executive branch, because guess what? They're not there at the request or nomination or appointment or anything else of the executive branch or the legislative branch. And so they tend to invalidate statutes more often. They tend to overturn precedent more often. And this was the testimony I gave to Morena when I was at that legislative hearing. So be careful what you wish for. And anyway, and there's value to life or long-term lengths as well in terms of the independence too. So I'm not saying that's a bad idea, but I just, in direct response to that question, yes, they're more democratic. You have to weigh in the balance whether that's a good thing or, what the institutional consequences of that are.
If I may, I'm very I have a different idea on that issue, but I think it's a very debatable, and it's very interesting, to hear Stephanie's arguments, because I think the truth is traditionally the justices and judges have less legitimacy because they're not appointed by popular vote than the executive or legislative branches. But I think that this legitimacy can be actually, you can fix that legitimacy deficit in other ways. And one way is transparency and accountability. And I think that's maybe the issue that we have to go forward in Mexico. This is why I said that the decisions that Chief Justice Norma Pinem made lately were good news, because they are in favor of this, transparency. And I think we need much more transparency than that. That being said, I just want to remind that, the Special Rapporteur on the independence of judges and lawyers, and from the UN, and the Inter-American Commission on Human Rights, they both recommend that judges should be appointed on the basis of, their merits and their trajectory, not on the basis of electoral decisions or political decisions. And I think one of the problems in Mexico is that, it's quite attractive, to think, you're not going to have the executive or legislative power branches appointing judges because you're going to go through popular votes. But in Mexico, if you have to compete for an election, and I think it's the same in other, countries, you will need money to have a campaign, and these might, imply that you receive money from people and you will owe them, your election. So you don't have like the independence, and you can have conflicts of interest and etc. So I think I would favor a system where you would have, exams to appoint judges, and the best judges should be, you at least as a step, to get the position. But that's, one way to see things.
Thank you all very much. I think we have time for one more question since we're getting close to 1:30. How different is it in terms of the hiring process in the Supreme Court and the Council of the Judiciary in Mexico and SCOTUS on how the justices choose their clerks and other officials? That is the question. Anybody want to start with that one?
Julia may know more, and Laurence, about how that works in Mexico. I have an idea, but I'll listen to you first. Go ahead, Julia.
Okay, so maybe also Lauren can complement. So in Mexico, so each justice has about 10 clerks. These positions are not restricted to 1 year, as is the case in the United States. The clerks in the Supreme Court can stay for actually a lot of years, depending on the justice. Each justice has the prerogative to select their own clerks, essentially in any way they want. What is interesting is that we have seen, especially from the incoming of outsiders to the Supreme Court, we have seen very diverse methods for selecting judges, for selecting clerks in the Supreme Court. For instance, some justices actually publicize the positions and create some kind of examinations to select their clerks, as former Justice Franco. Other justices, like Justice Cosio, used to appoint half of his clerks from, people who studied abroad at Yale, Stanford Law School, to help him with recent debates internationally. But the other half, he used to select people from people that came within the judiciary that know the nitty gritty. This is a really nice book by Josafat Cortez. He explains that. Other justices simply inherit the clerks that living justices left there. And so the clerks know their career. To be clerk in Mexico, it's a very prestigious position. I mean, it's people that really know a lot. And it used to be before trial and appellate court judges get their position by examinations. The clerks used to be the ones who became trial and appellate court judges after their justice appointed them. but this was before the merit reform. I don't know, like Laurence, you may know a lot. You may add something, and then Stephanie can tell us about the youth court.
No, actually, the interesting thing is now they're a part of the professional career service of the judiciary, the federal judiciary, which means that even though there's no selection process established for them, because, you know, as Julio said, it's up to every justice. The problem is that they have the problem for me, in my opinion, is that they have a direct way to become, appeal judges. It means, because since the last judicial reform, the only people who can, compete for a position of appeal judge is a judge or a clerk from the Supreme Court. But, you know, people who have been, in the judiciary for years and who would like to compete and maybe not going through the judge position cannot compete for that. And I think that's a problem because, as Julio said, there's no, selection process that is so it's a kind of unfair, I think. But that's the only compliment that I would like to make. Thanks.
So just a quick counterpoint from the federal judiciary in the U.S. I think the power of clerks is probably much diminished relative to what may happen in Mexico. And the only reason for that is that at the U.S. Supreme Court level, of course, they're only taking about 80 cases a year to decide. So the justices are not as dependent upon the clerks to identify, what the proper outcome in the case might be and make recommendations. They do, the clerks do, depending upon the chambers, but I think they have less power. Now, there have been some studies that show that the clerks have, some influence over the justices, to be sure, but I think they're less. They're certainly not part of any kind of career path toward becoming a judge. That's not. I mean, oftentimes they are, but not necessarily. And I can just speak from experience because I clerked for a judge that's at the U.S. Court of Appeals, right below the U.S. Supreme Court. And, I wrote bench memos and helped draft opinions, but he was the one who made the decisions, not, So I do think it's probably less, it's certainly a prestigious thing to do, only lasts for a year. It's not a career path at all. There are staff attorneys that might work on the court for years and might be sort of clerks of a sort, but not like the prestigious positions. And there's no admissions exams. The only way to get a clerkship on the U.S. Supreme Court and other courts is to be an excellent law student. That's what you have to be, an excellent law student, preferably from Harvard, Yale, some other fancy Ivy League school. But that's not necessarily a prerequisite, but often that's where they come from. So.
Thank you all very much. And we have about 3 minutes left. And I think that, because of time restraints, I think we're going to end our event here this morning. But I would like to thank our co-sponsors again, Mexico Evalúa and ASU, for their support. Obviously, our 3 wonderful panelists, Julio, Laurence, and Stephanie, thank you so much for your insight, for your knowledge, for the experience that you have shared with our audience. And a special thanks to Edna Jaime for being here with us today, and to all of our viewers for joining us during this session. We hope to see you in future events, and we hope that you have a great day. So thank you very much to everybody. Thank you.